by the CCI's chairman, Dhanendra Kumar. Mr. Kumar, thank you so much for joining us here at CNBC TV 18. First, begin by telling our viewers, what exactly do Section 5 and 6 of the Competition Act deal with?
Section 5 and 6 of the Competition Act deal with mergers and acquisitions, taking over of controls. The idea is that it's a comprehensive act. In the integrated functioning of the Competition Act, we have to ensure that the competition in the market is not adversely affected, because competition is good for the economy, competition is good for the consumers. So, theoretically speaking, if there is a cartel or there are anti-competitive agreements, and if company A buys out his competitor company B, then it is seen whether the acquisition, merger or taking over of control is anti-competitive. But under the Act, only larger acquisitions where the companies involved have a certain turnover or certain assets. At the moment it is 1,000 crores for assets, 1,500 crore, 3,000 crore for the turnover, which is likely to go up because it's supposed to be cost indexed every 2 years. So it should go up to 1,500 crores for the assets, and likewise. So only those would come, which will not be too many, but we'll be looking at those primarily with a view to seeing whether there is an appreciable adverse effect on competition. And we also hope that 90 to 95% would be cleared within a period of 30 days, and only 5 or 7% will go on for a detailed scrutiny, even which we would try to clear within a matter of 180 days. We have put our draft regulations on the website, which after this notification of Section 5 and 6 could be given effect and could be issued, could be notified. But I wish to assure both the industry as also the consumers that we'll be adopting a very pragmatic and rational approach which will facilitate the growth of industry, which in any way would not hinder or impede or retard the industrial growth or fresh investments into industry. If at all, this would mean legal certainty for the economy and for induction of fresh investments into the Indian economy.
Right, Mr. Takes a really long time, finally been notified. Are you also, have there been any changes in what you define as anti-competitiveness? Is there any change in that?
No, not really. In fact, we have been keen that this whole system, structure, mechanism is put in a position which is best for Indian industry and Indian economy, and we have been carrying out intensive consultations with industry and other stakeholders all the time. And I think whatever has happened is very rational, very balanced, and as the Secretary just now mentioned, this is an integrated scheme of the Act. The Act has been passed by the Parliament. Under the provisions of this Act, every section has to be individually notified. Sections 3 and 4, which relate to anti-competitive agreements, cartels, and abuse of dominance, they have been notified already on 20th May 2009. Section 5 and 6 combinations had remained, but since the whole thing is interconnected and integrated, it has been notified now. And as I said just now, in trying to implement the whole scheme, we'll be very rational and conscious of the fact that it should not in any way impede the growth of Indian industry. I heard that you asked a question about the international mergers or domestic mergers and so on. I may just clarify that in any such situation, we have to see whether there would be an appreciable adverse effect on competition in the relevant market in India. We are only concerned with the domestic market. It could be a combination anywhere between the Indian industry and foreign industry or whatever else. And there are parameters defined for seeing what would be the appreciable adverse impact in the Indian market. For example, there could be appreciable adverse effect by virtue of competition or level of combination or extent of barriers to entry or countervailing power in the market, and so on and so forth. Likewise, if there is a failing firm, there is a standard norm failing firm defense. For example, if a company A wishes to buy out a company B which is going to fail in any case, then there would be no appreciable adverse effect, and accordingly they can take this defense of failing firm, and this normally automatically allowed. So as I said, we will be very reasonable, very rational, and most of the cases, we expect 95% cases would be cleared within a period of 30 days. In any case, the number of cases which would be coming to us would be above the threshold, which would not be far too many.
Right, so you're going to be rational, you're going to be reasonable, and you're going to clear those cases within 30 days. Exclusively on CNBC TV 18, so you heard it from the two people that matter. Notification of Section 5 and 6 to do with M&A provisions, threshold limit of 1,500 crore rupees for assets, another threshold limit of 4,500 crore rupees. As far as the turnover is concerned, the CCI chairman promising here on CNBC TV 18 that they're going to try and clear all the cases by 30 days, they're going to be fair and they're going to be reasonable. So that's the story we broke for you exclusively here at CNBC TV 18.